Recording in progress.
The Supreme Court of the State of Washington is now in session.
Good morning. Welcome to the Washington Supreme Court. Today is May 19th of 2022. We're hearing three cases by video conference. We are joined today by Justice Pro Tem Andrew Toynbee. Justice Montoya Lewis is recused. The first case for today is the State of Washington versus Sabelita Hawkins. Opening is Kate Benward for 13 minutes. Response from Stephanie Guthrie of 20 minutes with 7 minutes reserved for rebuttal. Counsel, please proceed.
Thank you. May it please the court. Kate Benward on behalf of Lita Hawkins. A person convicted of a felony faces numerous barriers to obtaining housing, education, and employment. These barriers are felt most acutely in communities of color who are overrepresented in the criminal legal system and who face greater discrimination for having a criminal conviction. The trial judge's decision to vacate a felony conviction is a decision to restore a person's liberty, equality, and dignity. It is not one that should be made arbitrarily. In Ms. Hawkins' case, the state agreed that she qualified under the statute to vacate her nonviolent felony conviction. She could not have known that the trial court would look beyond the fact of her conviction to ignore the mitigating evidence that supported that reduced offense, to find that she in fact was guilty of something greater, and to deny her relief because of it. That was an abuse of discretion, and Ms. Hawkins asked this court to limit a court's discretion to the crime of conviction, to consideration of the crime of conviction, and the period of rehabilitation, which here the court absolutely ignored when she presented evidence to the court of one, supporting mitigation for the reduced offense, but also what she had done in the community. The court again outweighed these unproven allegations to deny her relief. In reversing and finding that the court abused its discretion in this case, this court should provide lower courts criteria for determining when and how to vacate and what considerations are proper, so that people don't have to come back again and again and be at complete mercy of the court, who may make decisions that have nothing to do with the statutory criteria of rehabilitation and the eligibility of a conviction.
And what are the criteria that you're proposing we adopt?
So the statute actually provides the criteria, the RCW 9.94640. It provides a very narrow set of convictions. So the legislature has already spoken about the qualifying crimes. So a court would need to assess, does it meet the statutory definition or the requirements under the statute? The other criteria of that statute is the time in the community where a person had no new offenses. And so it's a forward-looking analysis. There's nothing that a person can do to change what has happened in the past with the crime that they either pled guilty to or were found guilty of. Where a court can exercise its discretion is to the forward-looking focus of the statute. If the court had questions, it would look at that. In Ms. Hawkins' case, that 5-year period where in the community, she had no new offenses and she restored her mental health and did everything that would be expected of somebody who was convicted of a nonviolent offense, as she was. And so those are the limiting criteria that are already provided by the legislature.
Could I ask you a follow-up question to that, Ms. Benward? So in the first step, looking at the crime of conviction, and you correctly point out, of course, that the statute lists the qualifying crimes of conviction. Does your argument encompass that those, if whatever the crime of conviction is, the judge considers that simply as a threshold qualification, and that the facts underlying the events that gave rise to that conviction cannot be considered?
Correct, because the legislature has provided that. They have already cut out most felony offenses. It's a very narrow category that actually do qualify. So if we're then to say that a court can undo what the legislature has already designated as eligible offenses, that in essence takes out what the legislature's intent was in carefully crafting those narrow set of convictions.
Counsel, could I ask you whether if in the court has to look at rehabilitation factors, but can't the court look at what the underlying facts of the crime were, because they can then, I mean, rehabilitation requires a threshold, right? So where did we start? And then how did that rehabilitation show? So I don't know how a trial court is going to know rehabilitation when they don't know what the crime itself involved, other than, the title of the crime?
Well, the title of the crime would reveal the crime. And to the extent that the court would look at that, and it would be that threshold that is met, to the extent that it would have to be balanced with the evidence of rehabilitation that followed. So it can't be a barrier in itself, because there's nothing that anybody can do to change that. And the legislature has said that is eligible. So certainly a judge could look and understand and might even remember what happened when it decided to either accept the plea to the offense, or the jury found that the person would be convicted of that crime. So they can look at it, but it can't be to limit their eligibility under the statute. It would need to be in relationship to what has happened since then, because the New Hope Act is forward-looking. We are seeking, the legislature has said it's for reintegration, for rehabilitation. And so if we tie somebody to what happened, and even mere allegation that at the time the state actually didn't even prove, and that they can never change that is contrary to the purpose of the act. And so, and to the extent that a court, sorry, to get back to your question, to the extent that a court would consider it, it would be in light of rehabilitation, but it itself cannot be a barrier, those considerations, to relief under the statute.
Let me run by you how I see this statute and get your reaction to it, because I think the trial judge does get to consider the underlying facts when deciding whether or not to vacate. But the way I see it is there are really 4 parts in the statute, 3 of which are ministerial and 1 requires discretion. The first is whether there's a conviction that qualifies to be vacated. So that's the first one, and that's a legal question, which we would review de novo, and I think is a ministerial question. The second one, is there a certificate of discharge? Same. Third one, are there any disqualifying events that would preclude vacation despite it being a qualifying conviction with a certificate of discharge? Also ministerial. And third, has there been a sufficient level of rehabilitation to warrant the vacation of the underlying conviction? And I think you would look at that underlying conviction and see what the issues were, and then see what progress the person has made, but it would require a careful consideration of the rehabilitative efforts in the interim. What do you think of that view of the statute?
I think it's essentially correct in that the discretion that a court has is the forward-looking discretion, and it's the question of rehabilitation. It should be presumptive evidence that a person is rehabilitated when they have 5 years in the community with no new offenses. But it is true the statute does provide that that would be where a court would exercise its discretion. So back to the point of how it considers those underlying facts, it wouldn't be to transform that into a different crime of conviction or to consider it as disqualifying, but so it could be considered in relationship to the rehabilitation that's followed. And again, that would promote the purposes of the act, which is forward-looking and providing people an opportunity for rehabilitation and reintegration. And let's go ahead.
Oh, I guess maybe we were all leaning in.
Yeah, sorry, I wasn't sure.
No, that's all right. So within that framework and understanding that I think you're agreeing that the court would necessarily have to look at the background facts and the context to assess the forward-looking rehabilitation. How does concern about risk and safety then factor in? And in particular, of course, this case involves tragedy in a mental health episode. So you talk about the court looking at crime-free years in the community, but what about the court's discretion to assess how that mental health condition can be managed in looking at future risk?
So, in this case, that evidence actually was before the court, but the court ignored it. And so there will be cases. In this case, there actually was evidence that the mental health has been absolutely managed in the community, and that was expected from the very outset of this case. And that's exactly what happened. And that's why she was found guilty of a reduced offense, because her culpability was reduced due to her mental health condition. And the evidence was that she treated that. So, Justice Stevens, that could be considered, and here that was the evidence. But to go back and to say, well, when I look back at the underlying allegations that were not in fact the crime of conviction, to say that those static factors, those static allegations would outweigh the mountain of evidence of rehabilitation that was contemplated in this guilty plea itself, certainly isn't contemplated by the statute. So there will be a court, it has already been told by the legislature, these are the offenses that they're non-violent by definition. They can't be crimes against persons as defined by the legislature. So already there's a presumptive, the legislature has presumptively told judges what qualifying offenses are ones that are worthy of vacation. And so to look and to find other evidence to show that it's not, without considering rehabilitation and time in the community, would undo the purpose of the statute.
Can I ask about what your request is then? If the court finds that the court below abused discretion and didn't engage in the forward-looking analysis that the statute requires, what should happen then?
So this court should reverse and be clear why, because courts don't have guidance at this point. Courts don't know what to look at. So in the case of this court, it took a shorthand and just looked at the file and found some allegations that jumped out and stuck with those. Well, we can't do that. That won't provide, in reversing, the court can't look at something else again that isn't the appropriate thing to look at. So this court should guide the discretion and say it is a forward-looking analysis. It must consider evidence of rehabilitation. And insofar as it looks at the crime of conviction, it must consider the mitigating evidence that resulted in the reduced charge in this.
Ms. Benward, assuming that the court agrees, or speaking for myself, I guess, seeing this as an abuse of discretion and agreeing with you that we should provide guidance to the trial courts, typically in a situation where we have found that the parole board or the indeterminate sentence review board or a lower court has abused its discretion, we either remand with instructions to that trial judge or using our standards for reassignment to a judge who has not shown prejudgment on the record, we remand to a different judge. I don't think that your briefs explicitly raised that, but do you have any feelings about remand to a different judge?
I think that should be available should Ms. Hawkins choose that, because she's twice been before this judge. She's already presented the evidence that hopefully this court would instruct a court to consider and didn't find it persuasive enough to overcome. So I think that she should have that ability to do that, to seek a different fact finder on this issue. So that would be, I would ask that that be available to her.
And are you asking this court to enter judgment of reversal and grant the vacatur, or are you asking this court to remand with instructions to grant the vacatur, or to remand to follow the guidance of the court?
I think we could remand with instructions to vacate, because the evidence here is so overwhelming that this was an abuse of discretion, and the evidence of what a court should have considered was ignored, and it erred in considering the evidence that was irrelevant. And so here, yes, I think the court can instruct the trial court to vacate. But also for future cases, I think that this court should, in so instructing, state what those criteria should be in additional cases. Thank you. I'll reserve the remainder of my time.
Thank you. Response, please.
May it please the court. My name is Stephanie Guthrie, Senior Deputy Prosecuting Attorney for King County, and I represent the state of Washington in this case. This court should affirm the trial court's decision as a reasonable exercise of discretion in this case. There were two legal issues originally raised in this appeal in the Court of Appeals: whether the trial court had discretion to deny vacation of an eligible conviction, and whether the trial court could consider the probable cause certifications in this case. It sounds like there's not actually a whole lot of dispute about those 2 points at this point. And the remaining main question is, was this among the range of acceptable choices? And what is very important for this court to keep in mind is what information was actually before the trial court in this case. Because this is a case where the underlying facts were undisputed and incredibly serious, where the mitigation materials presented by the defendant suggested that something as mundane as poor sleep could destabilize her mental health in the future, where there's no indication the trial court even knew the defendant's race when it rejected her initial motion to vacate. And
Ms. Guthrie, I'm sorry to interrupt in your introductory statements, but I want to challenge your recitation of some of the facts. I reviewed the record in this case, meaning the same record that the trial court had in front of it. And the trial court said it reviewed the record, including the certification for determination of probable cause. Attached to that document was the arrest record, which has Ms. Hawkins' race as capital B, which I think we can all acknowledge means Black. So I saw it in the record. So I think there's two options for your argument. Either the trial court didn't review the record and didn't review the mitigating materials because that was part of the record, or the trial court did review the record and did know that this was a Black female Navy veteran in a context where systemically medical care is often found wanting to each of those groups.
And Your Honor, when I read the trial court's ruling that it reviewed the PC cert, I do not interpret that as also stating that it read in detail the super form that was filed with that. I certainly can't say the trial court didn't know her race, but I do think that the PC cert itself does not mention her race.
But if you're arguing that the trial court really can't be credited with having read that portion of the record, how do we know that the trial court really read the substantial mitigating evidence that was presented to it by the defense?
I think the trial court read the documents it said it read. And so I do not dispute, I think regardless of whether the trial court knew the defendant's race or not, there is no evidence in this case that any sort of racial bias played any role in this case. The most important, some of the most significant mitigating evidence, which the defense claims the trial court ignored, is the statements at sentencing. And that was never put in front of the trial court. The transcript did not exist at that point. That hearing was transcribed as part of this appeal after the denial of her motion. And that's where we really see the state's position on the reasons it engaged in this resolution. That is where we see the state explain that it agreed that her conduct.
I find it so surprising that the state is taking this position now, since the state supported the original disposition because of the acute mental health factors animating the crime. The state agreed that she was statutorily eligible. The state did not disagree with the court exercising its discretion in favor of granting vacatur. And the state was throughout acknowledging the rehabilitative steps that she took.
Just because the state took that position in the trial court and did not object does not mean that it was an abuse of the trial court's decision to deny the motion. There were valid reasons here on which reasonable minds could differ about whether vacation was warranted in this case. And what the trial court did not have in front of it is information about why the state engaged in this resolution, information about that the fact that the state did agree that her culpability was greatly reduced by her mental state. The information the trial court had was the defendant's own mitigation materials, revealing her view on what had happened and why it had happened. And it had the fact that the charges were greatly reduced, but reductions happen all the time for a variety of reasons, not all of which have to do with the state's assessment of the defendant's culpability.
Didn't the mitigating material that Ms. Hawkins submit explain exactly the course of proceedings in this case and why the original resolution was entered into to enable her to get the benefits of VA treatment and be in the community?
No, Your Honor. There was the plea agreement, which clearly describes the deal, but there was nothing in the mitigation materials presented to the trial court that explained that the state agreed, that the state had actually planned on doing a resolution of not guilty by reason of insanity until the issues with getting treatment through the Veterans Administration came up. All of that is only revealed in the transcript of sentencing. It did not exist at the time, and the trial court was never asked to go back and listen to the recording or in any way informed about what had happened at the sentencing hearing. And that is some of the most powerful mitigating information in this case that can really shape how one views it. But none of that was known to the trial court at the time. So this court really needs to consider, what the trial court knew, which is it knew the defendant's position on why the resolution happened. It did not know the state's position on why the resolution had happened. And given the very serious facts of this case, given that the defendant's own mitigation materials indicated that, her mental health could be destabilized if she was suffering from poor sleep, that sort of thing creates a legitimate concern that could concern a judge and feel that vacation is not warranted in a case like this. And one of the important things in this case is that, just because a crime is eligible for vacation does not mean that the legislature thinks that every instance of that crime is eligible for, should be vacated. If the legislature thought that, they would have made vacation automatic for certain crimes or removed discretion to deny vacation for certain crimes. But not all of the offenses that are eligible are nonviolent. Assault 2 is a vacatable offense, right? Not every assault 2 is created equal. Not every felony harassment is created equal. So
Well,
the legislature intended.
let me ask you a question about your assertion that the crime of conviction, if it had been a crime of violence, might be different from the ordinary crime listed as a prerequisite to vacatur. I read the statute as a legislative determination that these crimes are eligible for vacatur. Other crimes are not, but we've made a decision that these crimes are eligible for vacatur. If you're convicted of that crime, if you have a certificate of discharge, if there's no later disqualifying factors, you are eligible. And the discretion seems to me to be based on, has rehabilitation occurred? Using that crime as a baseline, where is the defendant now? You seem to be arguing that the legislature is not treating the qualifying convictions as prerequisites to vacatur, but as only possible prerequisites to vacatur. How do you read the statute that way?
I read them as they are absolutely prerequisites, but they're not sufficient. Originally, right, before the SRA, the courts had broad discretion to vacate pretty much any offense they felt like. And then the legislature reined in that discretion and said, no, we're going to make certain offenses and certain circumstances disqualifying, and the trial court retains broad discretion for the remaining offenses. And they have slowly altered what narrowed the category of offenses that are disqualifying. But I think the legislature clearly intended that these offenses are not, certain offenses are not automatically disqualified because there will be some fact patterns in which vacation will be appropriate for that kind of offense. That does not mean that the legislature thought every fact pattern should be vacatable if the defendant remains crime-free. So I think it is, the legislature said, we know for sure that no one convicted of a Class A felony should be able to vacate that. No one convicted of a sex offense should be able to vacate that. But when it came to offenses like felony harassment, assault 3, assault 2, they basically said, we think there may be some cases where vacation will be appropriate. Therefore, we are going to allow judges the discretion to vacate in these cases if they find it appropriate. But in no way was the legislature saying everybody convicted of this offense, no matter how egregious the facts, should be able to vacate their conviction if they remain crime-free long enough. Or as Justice Madsen points out, where the facts of the crime tie very directly to kind of what is our baseline for rehabilitation? Where did this defendant start? How much progress needs to be made before vacation can be appropriate? And what kinds of concerns should we be thinking about? When you have an offense like this, where mental health was a big component, obviously one of the concerns is going to be, how confident are we that this will not happen again? And so I think it is absolutely valid for a trial court to say, the facts here are so concerning that in the absence of a way to be certain that this is not going to happen again, or in the absence of, additional information about whether the state agreed with the defendant that this was purely about mental health, it's not appropriate to vacate. So the trial court's decision here is absolutely one about reasonable minds could differ. A reasonable judge might have viewed the same evidence and said, you know what, I think on this vacation is appropriate, but that does not mean it was abuse of discretion to reach the opposite conclusion on the evidence that was before the trial court in this case.
This type of case always troubles me when I think that if you're in front of one judge, you're going to get one result. If you walk next door and in front of a different judge, perhaps a different result. Our role is to try and come up with some rule to establish a consistency of results. Can you see any way forward in this case for us to guide that determination so to accomplish consistency?
I think in many ways, the legislature, that is part of the legislature's job, right? The legislature has tried to decrease inconsistency by restricting certain convictions. The purposes of the SRA also guide this kind of decision. But just as with sentencing, the court cannot completely eliminate, even the legislature cannot completely eliminate, obviously, the fact that reasonable minds can differ on these issues. So there is no way to ensure perfect consistency. But if trial courts, can make these decisions in light of the purposes of the SRA and bounded by the limits on the discretion imposed by the legislature, systemically, hopefully we are going to get roughly consistent results. We're never going to get perfect consistency. We don't get that in sentencing either.
Can I follow up on that and ask, in a different context, dealing with parole board hearings, where we've also seen big swings in outcomes. We've discussed static factors and forward-looking factors, and that the statute mandates a forward-looking examination. Maybe you could address that here. Do you think that's comparable here, that perhaps the guidance needed is that the facts of the crime are never going to change, but what needs to be at the focus is what the statute puts in focus, the forward-looking examination?
I disagree. I think vacation is different in some important respects, because vacation is about reaching back in time and undoing something that happened in the past, removing this conviction from the defendant's record. This is not simply a forward-looking, rehabilitative focused decision the way parole might be, because vacating a conviction sends an important message about this crime. And to the public or to the victim, this can essentially say, we're going to just wipe this away and pretend it didn't happen. Now, obviously, there are contexts in which a vacated conviction can still play a role in narrow cases, but this is not simply a forward-looking decision. This is a decision about, what was the conduct here, and should this conviction be wiped away? And there are cases where that's appropriate, and there are cases where that is not. And the legislature has clearly delineated certain crimes for which they feel it's never appropriate, no matter the facts.
But clearly the statutes, the New Hope Act, the vacation statutes are looking at trying to remove significant barriers to people being able to move forward. That's the clear policy in these. So doesn't it matter to the analysis that if one does reoffend, this isn't wiped away forever? Doesn't that matter to what you're talking about, which is that does this really just go away if the motion is granted under this statute?
I don't feel like on this record I can speak to whether there are going to be lingering effects after a conviction is vacated. Certainly a defendant is entitled to respond that they have never been convicted of a crime after it is vacated. But I think, in this case, this is not a good case in which to necessarily craft new factors to direct trial courts, right? The defendant has not proposed any factors that trial courts should have to consider. That was not litigated in this case. There have been no authority cited by the parties to that issue. The issues here were, did the trial court have discretion to consider the probable cause certification? And did the trial court have discretion to deny a motion to vacate a statutorily eligible conviction? And those are
Is it your position, counsel, I'll go back to my earlier concern, that discretion is pretty much unrevealable, or would it move the rule towards the legislative policy if we establish that there's a presumption that the motion would be granted unless the trial court makes and enters specific findings to establish why the vacation is not appropriate? Then we'd have something to review.
I think any presumption needs to be established by the legislature. There's no evidence here that the legislature intended a presumption of vacation. They very clearly did not create a presumption where they clearly could have. And when the legislature expanded, or I guess contracted the ineligible category of crimes, when they made, for example, assault to potentially vacatable, one of the main arguments in favor of that was that trial courts would still have discretion on a case-by-case basis to weed out those assault twos that warranted vacation from those that didn't. So I think it's not that this discretion is unreviewable, but that the review has to focus on what the trial court knew, not what this court knows, when those two things are different.
Counsel, it's kind of concerning, I guess, where we just look at what did the court have in front of it and then make a guess, I guess, as to why the court found that there was insufficient rehabilitation. Shouldn't we, at a minimum, require a balancing of the underlying crime against the rehabilitation, and know what the judge is thinking and why the judge is rejecting the rehabilitation evidence? Because that's really what it's a criteria. It's an important criteria, and yet how are we going to know what that balance is unless the court tells us what that balance is?
I think here the trial court did. I mean, I think it is implicit, but I think by citing the facts of the incident and the seriousness there, the trial court is implicitly saying that outweighs the information I have that would weigh in favor of vacation. I think, it was not an abuse of discretion here to not make that reasoning more explicit when this court had never directed that.
That's what I'm saying, is maybe we need at a minimum to direct that. If simply saying this is a serious crime, no, deny the motion for vacating, don't we have some obligation to be able to weigh or to at least evaluate what the trial court weighed, and how can we do that meaningfully? So wouldn't this be an opportunity to say, at a minimum, the court has to balance these considerations on the record so that the appellate court can have something to review?
I think this court could say that. I think in this case, the record shows the trial court did do that, albeit maybe not in as much detail as one might like. But this was not simply a, denied. The trial court did explain and implicitly was explaining that, the factors it was citing was outweighing the evidence that vacation was warranted. But yes, I think that this court absolutely could say there needs to be a more full explanation on the record. But it's also important to remember that these are cases that are often decided without a hearing. Defendants could certainly request a hearing. One was not requested here. So I think we shouldn't fault the trial court in this case that it didn't explain in more detail its reasoning. So I don't think there's a basis to overturn the trial court in this case. I think if this court wanted to direct trial courts in the future to explain their reasoning more fully, it certainly could. But I think it's important that this court doesn't modify the grant of very broad discretion that has been granted to the trial courts by the legislature. And the legislature, did not dictate any particular formulation in that analysis. And with that, I would ask this court to affirm the Court of Appeals and the trial court as a reasonable exercise of discretion.
Thank you. Rebuttal, please.
Thank you. The state essentially concedes if the trial court had the right information, it would have reached the right outcome in this case, but doesn't want this court to tell the trial court what that information is. This court, in recognizing that the trial court, and in the state conceding that the trial court with the correct information would reach the correct result, should instruct trial courts that they cannot consider a probable cause statement as the undermining the actual crime of conviction. Or
So can I jump in? I just want some clarification, because toward the end of your main argument, you thought that we should say that this was so outside the range of, I guess, the evidence presented, that we must reverse and remand with instructions to vacate. Does it not matter what the evidence actually was? There was no hearing requested. So don't we need to look at what the judge had? Because presumably, if this goes back, any judge would have everything. They'd probably have a lot more now because things have been transcribed on appeal. So how can we make a call on appeal to say we're going to order vacation based on things that are in the record that were never in the record in the trial court?
Well, what we're asking for is for the court to tell trial courts that they actually can't rely on a probable cause statement because of the unreliability. That's been at the heart of what Ms. Hawkins is stating. So that's one instruction you could give the court. A person can't just guess at what a court might need to see. I mean, Ms. Hawkins couldn't have anticipated that the court would fixate on that probable cause statement, and that she had to provide the sentencing hearing. She was entitled to have the court take her conviction at face value, and if it had questions about it, to look at why it was amended down, which it was in the court file. Her psychiatric report was in that the court relied on to impose this reduced offense was in the court file.
Was the sentencing record in the court file? Was there a VRP transcribed of the sentencing record?
I don't know, and I don't know what the court's notes were. Presumably not. It's not something that she made a part of the record, but we don't know what the trial court's notes were. Maybe it may be.
Weren't the documents from the prior proceedings there, including the state's recommendation for a first offender waiver?
Absolutely.
And the basis for that, which the trial court accepted?
Absolutely. So the information was there for the court to see that her crime of conviction was because it accurately reflected her culpability at the time, as agreed to by all the parties. And so for the court to look outside of that at unproven allegations, that's where the abuse of discretion lies. That's why this court can say that's error, and you can instruct other courts not to do the same. And to limit consideration.
Counsel, I thought when you answered my question earlier that you agreed that the certificate of probable cause is fair game in terms of trying to decide whether or not there's been rehabilitation. Are you backtracking, or am I misunderstanding you?
That is not what I'm saying. So it can be in the fact that the court has knowledge, right? It has a trial court file in front of it, and it probably in most cases was the presiding sentencing court. It's going to consider these things and know these things, but it can't rely on it to deny relief. And to use its discretion to reinterpret the crime to not qualify under the statute. That's what it cannot do. Of course, it's going to have that knowledge. It's going to have that trial record before it. But where it can exercise its discretion is in the forward-looking portion of its analysis. And that might be a measure to look at how far somebody's come. So if the trial court has concerns about the underlying facts or allegations of the conviction, it can look at it, but it can't be a barrier to obtaining relief under the statute. That would be limited to in relation to the rehabilitation that the person has had. We can't have people coming back again and again, guessing at what a court might consider important, which is what Ms. Hawkins has been subjected to. It's been nearly 2 years where she's been deprived of her civil rights because a court looked at something that it shouldn't have. And she can't have known that she would have to provide a record of proceedings to the sentencing court in order to convince it. In hindsight, we can say, well, it makes it abundantly apparent. But the real problem is that the court went outside of the conviction itself, and that was completely arbitrary and something that she couldn't have changed. She can't change those allegations.
Sarah, can I ask, is it clear? So we have we have no hearing. We have a pretty short decision from the trial court that indicates what it did look at. And I'm understanding your argument to be that no reasonable judge could deny vacation on the facts presented to this court. Am I correct about that?
If we presume the conviction is valid, which is what we have to do because the legislature has said she qualifies based on her conviction, and she qualified under the statute, and there was no evidence that she didn't. So under those circumstances, yes, it is, and it's no reasonable judge would find that. And to the effect that the court went and found she was actually guilty of something else that wasn't proved, yeah, that.
I guess that's what I'm asking about. You read this record as the judge finding that saying the mitigation evidence, I have no concern about risk or mental health lapses in the future. I'm making this decision because of the seriousness of the facts underlying the crime of conviction.
Those static allegations that were not, did the parties at the time, in terms of, agreeing to her reduced offenses, did not believe accurately reflected her culpability. So yes, that's, and this court could limit that kind of completely arbitrary interest by a later judge, and say that, he would look at, he had all the information about why this was reduced. This offense was reduced from more serious charges, but insisted that the unproved charge must still be true, and that those should dictate the outcome of the case. And so this court, in terms of developing a rule, should say the conviction and the time in the community presumptively makes a person entitled to relief under the statute, unless there's evidence that the time in the community is not reflective of rehabilitation. Yes, that should be granted. And if the state doesn't produce that evidence, then the court would need to put on the record very clearly how it's exercising its discretion.
I have a quick question based on something you just said, if I may, Chief.
You may.
I think that you just said that the trial court had in front of it the Western State evaluation report. And
that was in the file.
I'm not sure that. How do you know that?
I know that because in the sentencing hearing, they discussed, the court had reviewed the file, and there was a later Ishikawa hearing on whether it should be sealed or not. And so that's at RP, I believe 66, 67 in a January hearing. They actually litigated.
The sealing hearing was after the vacatur hearing?
Yeah, it was, and that's part of this record. It was in January that they discussed what was in the court file and whether, the privacy protections that should be afforded to that. So yes, that was in the file. That was evidence before the court that it didn't account for. I'd ask that this court reverse and with instructions to vacate Ms. Hawkins' conviction and to limit a court's discretion to the statutory criteria. And when a person is eligible for relief under the statute, they presumptively qualify unless the state can present evidence that the period of time in the community doesn't reflect rehabilitation. Thank you.
Thank you to both counsel for your arguments and your briefing. The case is submitted. We are in recess until 10 o'clock.